Good morning. I should like to welcome officials of the Equal Opportunity Commission and the Office of the Attorney General and Ministry of Legal Affairs to this inquiry. And I am Hazel Thompson, Chairman of the Joint Select Committee on Finance and Legal Affairs Committee, and I now invite members of the committee to introduce themselves, please.
Hi, good morning, Madam Chairperson. I am Ian Roach, Chairman of the Equal Opportunity Commission, and I will ask other members to introduce themselves on my right.
Welcome.
Morning, Madam Chair, members of the Joint Select Committee. My name is Shali Dalabai, and I'm the Manager of Corporate Communications at the Equal Opportunity Commission.
Good morning, Madam Chair and members of the committee. I am Haran Ramkaran Singh. I am the Director of Legal at the Equal Opportunity Commission.
Good morning, committee members. My name is Christine Cole. I'm the Conciliator Mediator at the Equal Opportunity Commission.
Good morning, Chair and committee members. My name is Debbie-Ann Trotman, and I'm the Administrative Officer for Acting and Equal Opportunity Commission.
Good morning, Chair. Good morning, committee members. I am Indira Rampal Chedi. I am the Deputy Permanent Secretary at the Office of the Attorney General and the Ministry of Legal Affairs.
Good morning, Chair and committee members. I am Shea Augustine Hamilton, Director of Finance and Accounts.
So I wish to welcome all of you to this public hearing into the efficiency and effectiveness of the Equal Opportunity Commission. I also wish to welcome the viewing and listening audience to this 16th meeting of the Joint Select Committee. So as I said, today the committee is convening its public hearing pursuant to its inquiry into the efficiency and effectiveness of the Equal Opportunity Commission. Members of the listening and viewing audience are invited to post or send their comments to the Parliament's various social media platforms, Facebook page, or ParlView, Parliament YouTube channel, and Twitter. The purpose of today's hearing is 1, to evaluate the performance of the Equal Opportunity Commission in the execution of its core mandate, including A, its ability to eliminate discrimination, and B, to promote equality among persons of diverse backgrounds. 2, to determine whether the resources, systems, and procedures of the EOC are sufficient to allow it to operate efficiently, and to evaluate the adequacy of the existing regulatory framework that informs the operation of the Equal Opportunity Commission. I will now ask Mr. Ian Roach, H.R. Ian Roach, Chairman of the Equal Opportunity Commission, to make brief opening remarks. 2 minutes, Mr. Roach.
Thank you, Madam Chair. Good morning, Madam Chair and members of the Joint Select Committee, to address the efficiency and effectiveness of the Equal Opportunity Commission, otherwise called the EOC or Commission. The EOC is a statutory body empowered and mandated by the Equal Opportunity Act, Chapter 2203, to work towards the elimination of discrimination and promote equality of opportunity for persons of different status generally. The Act covers 4 broad categories: employment, the provision of goods and services, education, and the provision of accommodation. The status grounds that are protected by the Act are sex, race, ethnicity, religion, marital status, disability, and origin, including geographic origin. The functions of the EOC are outlined in Section 27 of the Act. The central function is to receive and investigate complaints of discrimination from members of the public. We are one of the few bodies that can investigate complaints against persons both in public and private sector. To enforce the rights given by the Act, a member of the public can lodge a complaint with the Commission with or without the assistance of an attorney at law, and there are no costs or charges attached to doing so. Following this investigation, if it has been determined that there may have been a breach to the Act, we may invite parties to use our in-house conciliation process to help resolve the matter, as we are not an adjudicative body. This process is also free to the public. At the time when the local, regional, and international legal community is moving towards employing alternative dispute resolution processes as a means to help disputants to resolve their issues, the framers of this piece of legislation had the vision to include conciliation as a core process of the Equal Opportunities Commission. The Act also outlines a public education function to develop and implement educational programs to deliver on the EOC's mandates, such as publishing guidelines, outreach activities, and inclusivity sessions with organizations. Finally, the Commission is empowered to keep the Equal Opportunity Act and other relevant law under review and submit proposals to the Honorable Attorney General to amend the Act, a feature that enables the Act to progress with the needs of society. We have submitted our written submissions and stand ready to answer any further questions you may have on the operations of the EOC. I thank you.
So may I invite now opening remarks from Indira Rampal-Chedi, Deputy Permanent Secretary, Office of the Attorney General and Ministry of Legal Affairs.
Good morning again. On behalf of the Honorable Attorney General, I am Indira Rampal-Chedi, Deputy Permanent Secretary at the Office of the Attorney General and Ministry of Legal Affairs. The Ministry of the Attorney General is the arm of the government of Trinidad and Tobago responsible for providing legal services to the government and its various agencies. The ministry's obligations are primarily derived from the constitutional directives given to the Attorney General, which include acting as an independent guardian of the public interest and ensuring that the rights of all citizens are protected. Through the drafting of legislation, the AGLA also advances and secures the interest of the national community while defending enshrined constitutional rights. Falling under our remit are several statutory bodies and agencies which support and strengthen our functioning. The Equal Opportunity Commission, commonly referred to as the EOC, is one such body born out of legislation crafted to protect citizens against discrimination under the four broad categories of education, employment, provision of accommodation, and provision of goods and services. The EOC reports to the Attorney General, which, with regard to the fulfillment of its mandate of eliminating of discrimination and the promotion of equality of opportunity through advocacy, public education, research, and coalition of complaints. The Office of the Attorney General and Ministry of Legal Affairs also provides administrative support to the EOC in areas such as human resources and accommodation. The EOC mirrors the strategic priority of the AGLA to effectively securing the legislative and regulatory framework for equality and fundamental human rights. Through robust advocacy programs and tangible deliverables, the EOC empowers through education, strengthening the AGLA's mandate to provide accurate information to our Twin Island Republic. In our capacity this morning, we stand ready to answer any questions of this esteemed committee. Thank you.
Thank you very much. And this esteemed committee comprises a number of members, and they will now introduce themselves to you so you will know who will be conducting the questioning. Members, I invite you to do so now.
Good morning, members of the Commission and Chair. I am Saddam Hussein, member.
Good morning again, our colleagues. and members of the Equal Opportunities Commission and the AG's office. I am Marvin Gonzalez, member.
Morning, colleagues and members of the EOC and the AG's office and all officials. Lawrence Hislop, member.
Mrs. Scotland. There's no doubt that the work of the Equal Opportunity Commission is extremely important. We're talking about equality. And Thomas Jefferson, one of the writers of the Declaration of Independence, said, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness." And John F. Kennedy said, "All of us do not have equal talent, but all of you, all should have an equal opportunity to develop our talent." So the work that you do is extremely important. We will now commence our questioning to see how you have fulfilled your mandate and how we can assist you to even better fulfill this very important mandate that you have. Just a reminder that committee members and officials to direct your questions and concerns through the chair. Activate the microphone on your device when you acknowledge and turn it off when you have concluded your contribution, please. So we begin.
Chair, can I go first?
But of course.
Thank you very much, Chair. And of course, the questions are posed through you. I just want to ask the chairman of the EOC and other members, but first to thank you very much for the submissions to the Joint Select Committee so that we can, look deeply at your submissions and prepare for today's meeting. But if I were to ask you to state to the national community, who obviously would not have had the benefit of your written submissions, to briefly outline, in your view, what are some of the major accomplishments of the EOC over the last maybe 5 years, and what are some of the challenges that you experience in the discharge of your statutory responsibilities over that same period?
Thank you very much for your question, Member Marvin Gonzalez. The EOC over the last 5 years, in continuing in the execution of its mandate from the other boards and members of the Commission from its inception, have done quite a remarkable amount of work in terms of trying to eliminate discrimination and also to promote equal opportunity for all members of our society. Immediately, difficulty in assessing ourselves as being how successful we are is that it is very difficult to set up a metric of how to assess the success in this. I mean, the obvious answer to that, if we were really successful, is that we would have a need for the Equal Opportunity Commission. Yeah. But in the submissions we have written, we have given certain categories where complaints are lodged and complaints were investigated. And we gave you all a sort of a breakdown of what were the more prevalent forms of discrimination that the Equal Opportunity was called upon to deal with. And immediately, from my memory, what jumps at it is the discrimination in terms of employment. We have with us the Director of Legal Services, Mr. Haran Singh, who can give a further depth when I'm finished as to the nature of those complaints and the prevalence of them coming from year to year. So over the 5 years, cumulatively speaking, it seemed that employment discrimination in the employment sector seems to be the more frequent one that presents itself at the Commission for resolution. In terms of, and race will be the second. In terms of how we go about resolving these things, the conciliator, we have Ms. Christine Cole here, and which is a significant part of the mandate of the Equal Opportunity Commission, is to conciliate as opposed to adjudicate as in terms of a court. We are not that. We do not provide that. The Equal Opportunity Tribunal does that. And where that is concerned, that is also somewhat difficult to give a very accurate position of how successful we are, because first of all, it's a voluntary process that persons, once you file a complaint, it will be investigated. If complaint is found to have merit, there will be then probably persons will be written to and asked, invited to have a conciliation session if you think it can be resolved by conciliation. If the conciliation is successful, then an agreement may be arrived at, formulated in an agreement and filed at the Equal Opportunity Tribunal. What happens frequently is that persons may come together, may conciliate, and it's so successful that they resolve without having need for an agreement to be taken a formal setting, and then that would not be necessarily be recorded and reflected in determining whether or not how successful this session was. People just sometimes withdraw it as well. So in those circumstances, one cannot really give a figure or give a specific amount to say, well, this has been successful. We had 100 complaints. Some of them probably resolved them within a short space of time, within 2 or 3 meetings of conciliation. But I will leave the conciliator to give up more in depth to the public, because I think it's important, because between the conciliation unit and the legal unit, which I consider to be the engine of the Equal Opportunity Commission, where all the activities and work of the executing the mandate takes place, is important. And hearing from those who are on a day-to-day basis dealing with it, I think will help the population to have a clearer picture and have a real sense of the value and the type of work that is being done by them. So if, with that, I would like to invite Mr. Ram Karan Singh to give a disposition of what I'm suggesting in terms of the legal unit, in terms of how we gauge our success. Karan.
Yes, good morning, everyone. As the chairman said, we receive complaints on certain, the legal unit, is responsible for the handling of complaints. That is our core function at the unit. We have a complement of legal officers and investigating officers. So we receive complaints on, we can only investigate complaints based on what the statutory, as we say, the statutory criteria, what is provided for in the Equal Opportunity Act. One of the questions Minister Gonzalez had asked is what are the challenges we face? One of the challenges I think we face is that our act is limited to certain particular grounds. So that, for example, we have no difficulty in treating with the complaints that fall within our grounds. I mean, they're always operational issues. You're trying to call somebody or and they're not answering the phone. But these are things that the investigating officers are equipped to handle. Any investigation anywhere would always be plagued by these little issues, and that's as part of an investigation. So I don't really see that as challenges. I really see the broader jurisdictional issues as challenges. That is to say that we can only investigate complaints that fall within our statutory remit, so that a number of complaints that we get, we would have to, we would have to discuss with the person, well, your matter doesn't really fall within what is known as a status ground. And just to repeat, just to really explain, you have to ground your complaint on a status ground. That is to say, if you're claiming discrimination in employment, the chairman did mention that employment is the largest ground of complaint. You have to say you're being discriminated in your employment because of your race, your ethnicity, your religion, your sex, your disability, your marital status, that sort of thing. And the reality is that many of the complaints, I won't say many, but a lot of the complaints we get don't really fall within one of these status grounds. Sometimes someone says, I'm being discriminated against, and you ask them why. Well, my supervisor and I don't get along. We don't like each other. So he's giving me a bad performance appraisal. He's writing me all these letters, that sort of thing. But it's difficult to say that your supervisor is doing this to you because of your race, because of your religion, because of your sex, because of your disability. Now, we do get complaints that fall within the status grounds, but we also get a lot of complaints that don't. So from that point of view, we have advocated for an expansion of our remit to encompass other areas. And I think that one of the other areas that the legal unit is involved in, and we do this together with the corporate communications unit, and I'll defer later on to our manager of corporate communications, Michelle Dollaby. We are engaged in a lot of public education and advocacy. We receive requests from many stakeholders, many groups out there, many employers to come in, and I usually would come in because this is just a reality. The pre-COVID days, we actually went into the organization. Now, you know, in the post-COVID world, we do a hybrid of online and physical. So we receive a request to come in and do a training session. So our sessions could be anything from 2 hours to a whole day, depending on what the organization says are their particular needs. One of the questions we always ask persons are, have you heard about the Equal Opportunity Commission, or what do you know? Now, in the initial stages, people didn't know much, but I'm pleased to say that the more we've been doing this and we ask this question, the more people are able to put up their hands and say, yes, well, I've heard about this, I saw this, or I saw that in the newspaper, or I saw something like that. So that more and more people are becoming aware of who we are. Recently, apart from doing public education by going into a company, Ms. Dollaby will tell you, we actually tried to, we're trying to do what I call caravans, where we actually go into a physical location. We did this sometime last year in Tobago. Most recently, the staff went to, I think, Hilo in Gulfview. Yes. And, you know, you just engage members of the public and you ask them. And we are still finding that, so whereas when we go into an employer, you know, and we ask the employees there, well, what have you heard? Many employees, especially if they're HR professionals, they would have said, yes, we know about the EOC because, you know, we're following the legal professionals and HR professionals. But many of the persons on the street still aren't aware about of us.
Yeah.
Sorry, yes, or if they are aware, they don't really understand specifically what we're about.
Mm-hmm.
Yes, sorry, Minister, you wanted to ask a question?
No, I was just more or less emphasizing that what you're saying, that a lot of people don't know about the statutory responsibility of the EOC.
Yes.
All right.
Yes.
Just to follow up on this question, because I know other members might be they'll want to come in here. But what is the average timeline it takes to resolve complaints lodged at the EOC? And do you have a backlog of complaints waiting to be resolved?
Well, yes, yes and yes. The average timeline, it takes about a year on average or more, depending on how complex a matter is. Because when let's just go through the timeline. A complaint comes in, it has to be acknowledged, it has to be assigned to an officer. The officer then has to contact the complainant for a meeting or for an interview. Based on that, they might some complaints might come in with a large bundle of information, so there's nothing more to be sourced. But sometimes but many times you would have to ask the complainant, well, I need to get more info. You know, we need you to provide us more information, more documents, that sort of thing. When it comes in, then our remit is to write to the employer. We send what is known as we are empowered under our act to send a notice in writing, and listing out what is the information that we want you to provide. Yeah. Now, normally we would give 1 month in which to respond, but many employers might say, and quite reasonably so, well, you've asked us for a lot of things, we need more than 1 month, you know. So sometimes, I mean, that might take at least as much as up to 3 months, depending on how long, depending on, and also just to stick a pin, during the COVID-19 period, we were functioning throughout COVID-19, but we were working from home. And in the same way, many employers were working from home. So when we wrote to many persons, they said, well, you know, we need a bit more time. When that information comes in, then we would call in the complainant for an interview, a second interview, to say, well, we need to discuss with you the information that has come in. We need to perhaps get comments from you, feedback from you based on the new information that has now come in from the employer or from the respondent. It doesn't only have to be an employer. And sometimes the complainant themselves may say, I need to think about it further. I need to consult with someone. While our services are free of charge and you don't require an attorney, many times persons may say, I would like to consult with an attorney or an IR specialist or something. So there are lots of little things here and there that would lead to a much more prolonged process. It is not the same as what I would call a police-style investigation, where we just turn up at your door, banging on your door, saying, you know, please let us in, because we have to actually, it's a lot of paperwork involved in the process. Yeah, so we do have a backlog because as we were noted in our submission, we have only one functioning investigating officer at this point. So that there's a backlog which we're working as best as we can to manage. But until we get an increased complement in staff, we have a backlog at this point in time.
Can you tell the committee what's your backlog at this point?
I can't say offhand what the backlog is because I think all matters are being attended to, but it's not being attended to at the pace that we would like it to be attended to. So I think that's probably the better way of looking at it. It's a backlog in terms of not being actioned in a.
I'm just wondering, if you can say whether or not it's 200 complaints, 300.
No. It's nothing like that. I mean, for example, all of the complaints that have been lodged so far for the month of April, we're in May, sorry, those have been acknowledged, but they have not been assigned. So it's not 200 or something like that. It's probably about 15 matters, if so much. But as I said, even when they are assigned, there's only one person to handle it. So the legal officers are chipping in to help as much as they can. But again, it's just a matter of saying that scheduling meetings, for example, we would say we need to schedule a meeting with you, but we may not be able to meet with you within the next week. We might have to meet with you within the next 3 weeks or something like that.
Chair, if I may show you, just to put a bit of clarity on Mr. Carris's explanation to Member Gonzalez, is that
please do. Mm-hmm.
Yeah, the backlog, and when he said backlog, it's not in terms of the significance of volume like what you will hear happening in the other areas of our judicial system. It is because we don't have a very heavy flow of matters coming on a monthly basis to the Equal Opportunity Commission. That could be for the reason that people are not very much aware, or that we are making significant progress, or people are just being able to resolve their matters either in different judicial fora, or it is that we need to be more visible. So the average cases coming through the Equal Opportunity Commission on a monthly basis could be like 10, 5, 20. I don't even think it's 20 as much as 20 all the time, but we're within the range of 5 to 20, as an extreme figure. So you will find that the numbers are not going to, the way in which it operates is not going to go to a backlog that's going to be to have a significant number like 50, 60, and those kind of things like that. That would not be the case. But having member ask a question, that I am inviting Ms. Cole to give a comment, which I think is important, especially for persons seeking to understand what they can get by coming to Equal Opportunity. I think she plays a very critical role, right? Having the illegal unit process the complaint, another significant resolution part of it is the conciliation process. So if Ms. Cole could just give a quick disposition or explanation as to what happens when a matter is referred to her and what is the success rate, will be appreciated. Ms. Cole.
Thank you, Chair. Good morning, everyone. So the matters come to the conciliation unit after the investigation at the legal unit has been completed. When the matter gets there, we would take it from there and contact both the respondent and the complainant. We have a workflow at the conciliation unit, and we try to get the matter through the conciliation unit within 90 days. That has been maintained. However, there would always be some outliers. Some matters have stayed there for good reason, for perhaps more than a year. There was one matter that stayed for about 3 years, but that was with the consent of both the complainant and the respondent, with other things they had asked to put it aside. So the complainant and respondents are contacted, and we have pre-conciliation meetings with them before they actually get into the conciliation process. That's to prepare them so that when they get there, they know exactly what they're faced, that it's not a court hearing, that they're free to talk as much as they like to resolve this matter. And I have found that process, well, it's really very dear to my heart. That's what I do. So as I said, because it's unlike the court process, we really stick with our workflow to resolve it there within 3 months.
I don't think we have a strong sense of how many matters, like you have now in train. How many matters are engaging your attention right now? Can anybody give us that?
Ms. Cole.
At the conciliation unit right now, we have 16 matters that are active at this moment.
Do you have, outside of the conciliation unit, do you have any other matters which are engaging your attention?
Sorry, the investigation.
You have investigation,
yes.
You have conciliation. How many matters do you have in hand?
At the investigating
at the commission,
yes.
At all stages.
Yes, sorry, at the investigator unit at all stages, we have I would approximate it at 95 matters that are at different stages of investigation.
Thank you.
And this will be inherited over the last few years. This will have been overflows from other years coming in to current time frame.
Sorry, no. Sorry, just to clarify, no, we don't have many matters that are more than say 3 years old. So this would be over the last 3 years or so. I think what would have caused a bit of the delay, as I said, would be matters coming in during the COVID-19 period that we still have some of those that we're dealing with.
Mr. Hussain, I'll engage you now because I want to come back to you on those matters that are in train. But before we lose Mr. Hussain, who has another engagement, I'll give him an opportunity to ask his questions now.
Thank you very much, Chair, for your indulgence. My question is really based on the same topic of inquiry that we're on. I looked at the submissions of the Equal Opportunities Commission to this committee, and I note that the legal unit is only staffed by 2 investigating officers, one of whom is on maternity leave. And I'm asking that in context, and I'm using that as a context of my question also, that there's a position of someone called Senior Investigating Officer, and that position has never been filled according to the submission. And that person ought to have guided and supervised investigating officers. At the legal unit, we have 2 investigating officers, 1 on maternity, so we down to 1. Then there's no position of senior investigating officers because that position has never been filled. What is the current complement at the legal unit? Because it seems as though that the majority of work that the commission is engaged in, or where I know that the word backlog is being used, but where most of the matters, the attention of the commission is looking at, it's at that stage of investigation. And if we have issues with respect to staffing at the commission, can you firstly give us what is the complement and what is required in order to probably try to expedite some of these matters to reach the stage of conciliation? Because I think the school has quite some resources on her hand to deal with the matters of conciliation.
Aaron, you want to answer this?
Yeah, certainly. Well, to begin with, we need to begin in the context of saying, on average for the year, we receive, say, if we receive about 10 matters per month, let's just average it out of that, we receive about 120 matters for the year. So that realistically, our staff complement on the organizational structure was 5 investigating officers, 2 legal officers, 1 plus a supervisor, so that's 6, 2 legal officers, 1 a legal officer, 2 a senior legal officer, and a director. But realistically, I think that might be overstaffing for an institution that only receives, say, on average 120 matters per year. If I were to compare, three members of this committee are attorneys in private practice, so you would appreciate, having a complement of that size on, like I said, what I would call the organizational chart complement for say a legal practice that only receives 120 clients coming in for the year. I mean, that's a bit of overstaffing. So realistically, we had only filled up to a maximum of 4 investigating officers in the past. It had gone down to 3 investigating officers. We had never filled a supervising position because the investigating officers liaise directly with the legal officers. When a matter is assigned, a matter comes in, it is assigned to both an investigating officer and a legal officer. So that we had felt that filling the supervisory post was not necessary. We looked at it more as an aspirational post, and that perhaps if you wanted to promote one of the if you wanted to retain one of the officers and promote them into a higher post, that post was available. But we didn't see it as absolutely necessary to the functioning of the organization. If you had at least 3 investigating officers, currently we have but unfortunately we are down to 1 practically because one is on maternity leave. And then we have 2 legal officers, 1 and a director. So that's the current complement, of the legal units.
So just to be clear, 1 investigating officer and 2 attorneys. Yes. Currently, we have functioning at the EOC.
Well, yes, 2 attorneys. And if you add me, I'll be a 3rd attorney.
So 3 attorneys and 1 investigating officer. Yes. Don't you believe that we may need some more investigating officers so that matters can reach them in school in a more timely manner?
Yes, it is. I mean, we have been asking to see how we can. When we were 3 up to last year, and we would like to return at least to 3 officers because I felt that matters, the 120 odd matters were being handled fairly efficiently by 3 persons at least.
And with respect to, I know at the end of according to the statute, Equal Opportunities Act, at the end of the conciliation period, reports are normally generated.
Yes.
And those reports at the Commission for Public Inspection 1 or 2, the matters can be referred to the tribunal if you satisfy the criteria of the reports. Can you tell us, since the Commission has been operating, how many of these reports are at the Commission for Public Inspection?
Yes, we have a list. I can say it is approximately 50 matters. I can't give you, I can look into it and give you an exact number, but it's about 50 or say about 60 matters in total.
60. And how many matters have you as a Commission referred to the tribunal for adjudication?
Yes, we've also created a list of those. It is not all 60 matters that have gone to the tribunal. It would be less. The only way a matter can go to the tribunal is by firstly, creating this report. So it would be from that only a certain. I would say about 50 matters because there are some matters that we had gone through the process of creating this report and the complainant opted not to go further. So if I can, we actually have a list, but I can't give you the figure, but I would approximate it at 50 matters in total.
Sure.
Mr. Hussain, is this it?
Yes, thank you very much, Chair.
Yes. Tell me, specifically, how many matters have you referred, the Commission referred to the tribunal? Let's just take last year and the year before. How many matters have you referred to the tribunal? I want a specific number.
Yes, it is actually in our submissions, and if you were to give me a moment, we've given a list somewhere. Yes, if you were to look at table 10 on page 60 of the submissions, it's there, 2018, 4, 2019, 8, 2020, 6, 2021, 1, and 2022, 2. So if you were to look, if we were just confine 2021 and 2022, which was your question, it will be 3 matters. That's table 10 on page 60.
So between 21 and I would perhaps today's date,
yes,
you have referred 3 matters.
Yes.
To the tribunal.
Yes.
So you have a tribunal where you have someone of the status of a High Court judge sitting as a permanent position, yes?
Yes,
and
it is.
You have two assessors. And this person paid as a High Court judge, and the assessors, I think, well paid as well, like $50,000. Yes?
I'm sorry, it is the subject of a report of the Salaries Review Commission. The assessors, the judge clearly gets the same terms and conditions and salaries as a High Court judge. The lay assessors, their salaries and remuneration is contained in a report of the Salaries Review, SRC report that was laid in Parliament. I don't know it offhand, but it's a matter of public record.
Right. Okay. Well, I'm just going, because remember, I know there's an ongoing matter in the court. I don't want to get into that.
Yeah, certainly.
But I am just looking to see the position of the tribunal, where you have compared with the High Court, which is so inundated with matters, and you have matters there sitting in the tribunal, which could have been referred to the person who was, the head has the status of a judge with all the terms and conditions of everything. Would you agree that the tribunal is not being properly utilized or very, very, very unutilized?
Well, yes. I mean, the numbers speak for itself. I mean, when you look at when you compare the amount of matters that are docketed to a new High Court judge, and the members of this committee who are all practicing attorneys will have an idea of at least in terms of civil practice. I know member Scotland. Well, his forte is more criminal law. I don't really know how the criminal High Court works, but when you look at the docketing of matters of civil High Court judges, it really is the tribunal is quite underutilized.
Madam Chair, may I come in here, please? Just to add some further.
Please, Mr. Roach, I would love to hear you.
Thank you very much. Madam Chair, what is important, and it creates a bit of confusion for the public and even attorneys at law who are not specialized in this area of practice, is that the commission is such a unique operation. The commission, the Equal Opportunity Act, creates both the commission and the Equal Opportunity Tribunal. In order for matters to come from the commission to reach the tribunal, matters have to be conciliated at the commission first. The rate of there's no significant flow of matters coming that have not been resolved successfully or on some level goes automatically to the tribunal. First, you have to have is a voluntary thing. The complainant has to agree if the matter is unresolved that it should be taken further, either with our advice or without our, or we don't advise it. And that also then issue that is before under consideration for amendment. Because what you will have is that what is being sought, I think the tribunal was seeking such an amendment, is that persons that may have one of the discriminations as an issue or a complaint, for some purposes, could be able to file a direct action to the tribunal, right? That is something I believe is in discussion or something that has been concerned for the tribunal for the very reason that, there's not a significant flow of matters going there. Because if the success rate of conciliation, which is the prime purpose of the commission to conciliate and resolve matters of that nature without going into litigation, which is trying to eliminate the cutting up of the court or the tribunal, it means that if we are in fact very successful in what we are doing, it means the flow to the tribunal will be significantly less. Now, so because of the component of the concurrence of the persons who are before the commission for conciliation and resolve of their dispute, it is not an automatic flow that you have 10 complaints and they're going to end up. It's not like in criminal court where you may have PI or you just that you go through one step before you go there. It has to be on a concurrence of the parties involved to take it further if we advise that it could go further. And even that in itself, the process of doing that has a kind of a gray area, as we were saying, though, where it is that once the applicants, the complainant agree that the matter should be referred because it cannot be successfully conciliated or mediated, what happens is that the commission has to engage the tribunal. And when that is done, the complainant gets the idea that the commission is representing them as their lawyer, right? And that creates a sort of a false expectation and creates a bit of a confusion because we are not taking part on any side, either as a prosecutor or as a defendant in the matter. So these are things in the commission's operation that needs to be clarified for even the public to understand when they engage, what the reality of the expectations and what we can do and what we cannot do, as distinct from what the tribunal is all about. I know that helped put some sort of clarity to what you were asking, because I know having somebody as highly qualified and positioned as a high court judge, the chairperson of the tribunal, not dealing with the significant flows of matter seems to be not a very progressive use of resources, all right? And how best it can be,
That's the understatement of the year, Mr. Roach. It's very, 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 disconcerting. Yeah. I know the popular word now is concerning, which I don't like, but it's disconcerting. I mean, I guess somewhere along the line, you want to say that your conciliation process is so good, that you don't need to go any further. But yet I'm getting a sense that there is a backlog. And no, before you answer, I want you to clarify for us here. 39.2 speaks about the subject matter referred to remaining unresolved. Commission has fulfilled the requirements of preparing the report, sending a copy of the complaint, publishing the report, making the report available for inspection. And then with the consent, you send it on to the commission with the consent and on behalf of the complainant, and you initiate proceedings. You see those words? Initiate proceedings before the tribunal. This is 39.2. And when we come to 41.4, it says the tribunal shall have jurisdiction to hear and determine complaints referred to it by the commission. My question to you, referred to it by the commission, is that the same as initiating proceedings before the tribunal? Do you read it as the same? Because there's a divergence of opinion on this.
Yeah, that's a source of confusion. It is, as I said, it's a gray area, because when you say initiate proceedings, it gives the impression that the Equal Opportunity Commission now acts as a complainant in the matter and to represent the complainant against the defendant. When that is not so, what we prepare the necessary referral and refer it to the tribunal, and then at that stage, the complainant can, if so chooses, to have an attorney as his choice or her choice, as the case may be. Right? That is where that difficulty comes in when you talk about initiate. Right? Refer and initiate is being used interchangeably as being the same thing, but what it basically means is that we should just refer the matter, not engage in this litigation. I don't know if Hiram can give some actual examples or an example that will clarify it for you, Madam Chair. Hiram?
Yeah. So, sorry, you had a question, Madam?
I just want to know have you engaged like the Solicitor General or anybody to help you to bring clarity to this matter?
Sorry. When we looked at the judgment of the Privy Council in the Kenneth Surratt matter, which is a matter that forced the government to implement the Equal Opportunity Act, they did cite an opinion. It's there in the judgment. I can't remember if it was from some leading British QC at the time, Jeffrey Robertson, or one of those who was popular in that was a judgment of 1999. So whoever was the popular leading British QC at the time who opined that the Equal Opportunity Commission should be a party to the matters that are before the tribunal, so that and when one read the Hansard debates in Parliament, this legislation was piloted by Mr. Ramesh Lawrence Maraj, and when one actually look at the Hansard debates in Parliament, he actually spoke about this section. Again, this was just him speaking in Parliament. He actually said that he felt that the Commission would be a party in the matters before the tribunal. So that it seemed that the decision to say initiate proceedings might have been an intentional decision at that point in time. So respectfully, there wasn't anything to really clarify with the Solicitor General as to what was the meaning of the words initiate proceedings. It is something, and again, in our written submissions, we address that, what is meant by initiating proceedings. I think the problem we've had is whether or not we really wish to continue with that mandate given to us to initiate proceedings, or should we just, go to simply a referral process?
You see, Madam Chair, if I may again, right? When the commission is charged with one of its main aspects of its mandate is conciliating, right? So if you are acting as a conciliator, and upon the failure, so to speak, or the inconclusiveness of conciliation, and it has to be referred, probably could be a legal point. One loses the confidence that you have somebody that you are going to as an impartial institution to raise and try to bring parties to a consensus without being adversarial in a court. And then when it goes down, all of a sudden you become part of the litigation or the litigation process, and now you are taken aside. It will, to me, will undermine the confidence and the whole stature of the Equal Opportunity Commission being a commission there to first of all, to resolve issues by conciliation. That is where the mischief lies in terms about initiating proceedings.
Right. Mr. Scotland, you may be, yes. Proceed.
Madam Chair, good morning. Thank you very kindly. Madam Chair, my first area of inquiry relates to the strategic. Your submissions outline the key objectives for the Commission's 2021 to 2023 strategic plan, and that is contained at pages 8 to 10 of your submissions. Please indicate the degree to which the strategic plan has been completed.
The strategic plan, I mean, in terms of its rolling out, or in terms of it being formulated and in existence as our strategic plan until the end of the period?
Well, it can't be, if it's not completed, it can't be rolled out. So tell me the completed stage first, and then if it is completed, tell me about the rollout then.
Well, first of all, yes, it is completed, because before it was completed, we were engaging in rollout certain parts of it, as you see, between 2021, 2020 to 2023, right? It is being rolled out, and there's if you look at the submissions, there are parts of the submissions which deals with that, how it is being tracked, what aspect of it is being rolled out as we continue the work of the Equal Opportunity Commission. I can probably ask the MCC, Ms. Dolabai, to give an indication of the methods we use in terms of part of our mandate, because we were earlier on engaging in speaking about the conciliation processes, the legal department, and a substantive part of our mandate is dealing with the education, edification, making ourselves known and so forth, which is handled very competently, let me say, by the communication unit. So, Ms. Dalabai, could you please give some sort of clarity to Member Scotland, please?
Good morning again. Through you, Madam Chair, for the benefits of the committee and also the public, I would just give a brief on the work that the communications department does. So the corporate communications unit, we work closely with the research and legal units to develop database strategies to raise awareness and engage members of the public on the mandate, functions, and services of the Commission. So the categories covered and the status grounds protected by the Equal Opportunity Act. And we also partner with stakeholders to have high and targeted impact in various communities and engage the media to disseminate reliable, trustworthy and far-reaching messages. And this is contained in Section 27(1)(e) of the Equal Opportunity Act. That is the public education function. Right, so our strategies and activities, as best as we can, it's based on available data from the National Perception Survey that was completed in 2017, data we acquire from stakeholders and work with various communities through our various feedback mechanisms, and of course, data collected at the EOC on complaints lodged at our offices. So raising awareness on the Equal Opportunity Act and the Commission is a critical part of our messaging in our educational programs, because knowledge is power, and in this case, knowledge empowers members of the public to exercise their rights contained in the Act, and also to access our processes or services such as the complaints process. So one of the sources of information, and rather how we go about laying our strategy, is the line items that the corporate communication unit is responsible for achieving in the strategic plan. So for instance, under Goal 1, we have to work towards the elimination of discrimination in Trinidad and Tobago in keeping with our statutory mandate. And under that item, it's building a compelling EOC brand and public awareness of its work among local, regional, and international stakeholders. So public education, it's broken down into three major areas. Public education, which is the first. So we actually started last year, and we continue up until November of this year, our outreach caravan across the country to reach marginalized communities and those who may have been left behind when we had that digital trust during the pandemic. We also do inclusivity training with organizations. According to the National Perception Survey that was completed in 2017, one of the areas, and also based on our complaints process, one of the areas where there are many concerns is in the area of employment. So we do inclusivity training with organizations. We also assist them, guide them, help them to develop or create inclusive policies within the workplace. Under public relations, which is also a critical part of the educational program, we have a column series that started in September 2021. It is ongoing for the period September 2021 to December 2022. It ran every Monday in the Newsday newspaper on page 14, as well as its digital format. This year, it's every other week. We also do many media releases, appearances in the media, and so on. And starting this month, we're going to have our animation video series running on all the major television networks, TV6, CNT3, and TTT. We also work extensively with stakeholders to have access to and engage with various communities. We partner with the stakeholders, which will allow us to receive guidance on urgent and trending matters, address relevant issues, and make an impact on the ground in a meaningful way, as well as pool resources and magnify their cause for justice. So off the back, two of those projects that we have done in keeping with the strategic plan for the Commission is two TTT series. Last year, we had our Sex and Prejudice series, which addressed sex and gender issues and bringing together stakeholders that can put forward solutions, more or less, such as the CEDAW Committee of Trinidad and Tobago, CAFRA, Institute of Gender Studies at the University of Trinidad, University of the West Indies, sorry. The second program that we had also on TTT was the hard conversations, where we brought in various stakeholders to give them a platform so that they can speak from a first-person point of view, the type of impact that discrimination have on them. So for instance, the second episode on that program dealt with persons with disabilities, and so we were able to bring the executive officer from the Blind and Welfare Association, one of the directors from the Trinidad and Tobago Association for the Hearing Impaired, Joe Bryan, who is a young man who was born with one hand and no legs, who's excelling in his area, which is media. And we brought them together to talk about their experience and sort of make a rally and call the public to consider how they treat the persons with disabilities. And so we have
Ms. Lullaby, I know you can go on and on. But tell me, are you satisfied that you are making sufficient use of the electronic? Because, you know, I find more and more, I meet people and they say, no, I don't read newspapers, I don't buy newspapers anymore and all of that. But I think that the electronic media, you think sufficiently, you know, you're using the television and radio to get the message out to people? Would you say that you've done enough or you're doing enough in that area? Have you thought about developing skits with actual situations? Have you not read in newspapers about cases that reach the civil courts and said to yourself, but you know, if this person had come to us, we would have been able to resolve that and not clog up the High Court with these cases, because this is a matter that falls right within our purview. Have you never had that experience? You know, saying, I wish this person had come to us? Tell me.
Madam Chair, yes, I share your concerns, and these are items in the media that we do pick up on. I think, and I don't want to overstate it, that the work that we do in our public education is nothing short of a miracle. Our unit is, and we have achieved significant success despite the financial constraints and the human resource constraints at the unit. So, for instance, all of these projects that I'm mentioning, Madam Chair, the TTT programs, the columns, the radio shows that we do, all of that, the animation video that's going to be on all television stations, those were negotiated free of charge to the Commission. And so I do agree that there's room for us to put more out there, but under our current financial constraints, it is exceedingly difficult to do so.
Madam Chair, may I add something here, please? I want to get beside myself and jump jump before you probably may want to raise the issue. But one of the issues that sort of challenge our effectiveness is resources, financial resources, which everybody, I guess, every ministry, every department or most departments in the economy, certainly in the public sector, would say that they are challenged by resources. We given more resources, had access to more resources, both physical, in terms of human resources as well as financial, I think we will be able to do much more than what we are doing now. And really and truly, what has been achieved in terms of reaching outside of the traditional means of communicating with the public through newspaper. I do share your sentiments that more and more, especially young people, are not looking towards the traditional paper. They are looking on various social media to be informed. And I know there's been a concerted, direct initiative by the communication unit in the commission to do that very same thing that you have identified as a means of really reaching people in a wider community. That is really under consideration, and we have been challenged in trying to accomplish that to the extent that we would like to see it be engaged as part of our resources.
Through you, Madam Chair, I'd like to add to this. For instance, the international conference, which has been in our strategic plan for some time now, we have been trying to rally different stakeholders to come together to pool resources, both financial and human resources. But at some point, an international conference requires a significant amount of funding to pull off. So despite our creative and best efforts, we would still be in need of additional financial resources.
Madam Chair, can I ask the officials at the Ministry of the Attorney General if they can comment on the cries of the chairman and members of the EOC with respect to a lack of funding to fund all of these activities that they would like to?
Hi, morning again, True Chair. Okay, I understand the financial constraints, but we are normally will make requisitions to request to the budget division for the EOC. So what I can recommend is that you all will send your whatever submissions, because we are in the process of completing our draft estimates at this point in time. So at least we could input it into the submission, so that for the next fiscal year, we could ensure that you all have the necessary funding to carry out whatever project you all wish to engage.
I noted the EOC, let me just come in again. I noted in the submission by the EOC, it was indicated that the funding for their day-to-day recurrent budget is sufficient. I stand to be corrected on that, but I recall seeing that somewhere inside of there. They have some constraints with respect to their development program. My question to you is that, and the members of the commission, is that, do you have a development program? And if you do, what is the cost to implement your development program? And has that program been submitted to the Attorney General requesting funding so that a list of these projects can be executed?
Sorry.
That is for the AG's office as well as the EOC. I guess the AG's office, you would know your development program and the list of activities inside of there for the Equal Opportunities Commission. And of course, the commission must have an idea as to whether or not it has a development program and whether there's a cost to it. And if that submission was made to the Attorney General so that the requisite allocation can be made in the national budget.
Ms. Gustin going to answer that. We do have a development program. I will bring in Ms. Debian Trotman as our financial person within the commission to give some clarity to that.
Thank you.
I know that we have projects that we would like to do. However, I have not, and I assume here to start some contacts on the 22nd of January, on the 3rd of January, sorry, 2022. Since I have been here, no submission has been made to me to forward with respect to the projects that they would want to undertake, which would first have to happen. But since I have been here, that has not, I don't know if under the previous EU4, but since I've been here, that information has not been passed to me.
So you're not aware whether or not the commission has a development program?
No, that I have nothing submitted to me to pass forward, like I said, to provide those financial provisions. Because when you say, in order to get funds for these types of things, we would have to submit something that would tell them what is the cost, what we want money for, and that type of thing. For the case management that we want to do, I know that that is in a more evaluation stage right now. So that there's no real documents to submit to say, hey, we need $80,000 or we need, which is what is needed in order for head office to put in some kind of budget or put it into any kind of plan. So since I have been here, like I said, I don't know under the previous, but I'm not privy to that at this point. But since I've been here, received any document of that type to submit to. So
was this strategic plan shared with you?
Correct.
Yes, the strategic plan was shared with me. But in terms of the budget, to go with the strategic plan and all the different projects and things they would want to undertake for that year, for the particular year, no.
Well, you know, that is very critical. That is very critical because some of the issues that you are raising with respect to the constraints that you are experiencing for as a result of lack of funding, they fall squarely within a clear development program, which includes your strategic plan, your campaigns to educate the public, your social media campaign, and all of these other social media platforms that you need to expand your message, to sensitize the national community, and all these things. They fall squarely within the organization's development program. And therefore, it would be very important for the organization to have these things clearly articulated in a development program and submit to your line ministry, in this case, the Office of the Attorney General, so that they can make representation to the Ministry of Finance so that the appropriate allocation can be made.
Thanks. Chair, to you, could I just add something to what Member Gonzalez has been asking, right? And I do appreciate his directive, his suggestions. But what I can tell you from the Commission's point of view, in rolling out our strategic plans, there were a number of things which Ms. Dalabai was given some considerations to. And I guess the way in which it was done before and the way in which Ms. Trotman, who seemed to have had quite a bit of experience in the financial, public financing operations in government, that sort of kind of helped to focus how we go about soliciting and getting the type of resources we require to do the things. What we would have done, what was done in the past, it would seem that we would have go directly to service providers to get whatever we need to do, things that we need to do to get done in terms of very development programs, and negotiate with them. And then they will submit a bill, and then it will go, and then they will on. The most recently I've been part of this, one can be able to talk about this with some sense of I wouldn't say authority, but understanding, is that there was it was probably being done in a backward way or not in an alignment with how things were supposed to be done. And what was suggested to the board is that, as Member Gonzalez was saying, is that we're supposed to have a program, all the programs identified in mass, up front, and then submitted to the AO4, who then will submit it to the line ministry to get the necessary resources. I guess timing is also important to be aligned with the allocation for the particular year of budgeting. And so these things are now under consideration. I think we are now looking to move forward in doing this in a way in which it will be more efficient, so that we will get the resources necessary to do what we need to do.
These are very hopeful words, Mr. Roach. I've always known you to be a very proactive person, so that you're acting true to form.
Chair, if I may, through you, we had invited the Equal Opportunities Commission to make representation for their budget. And I do concur with the Honorable Marvin Gonzalez, Minister of Public Utilities, that this is important that you submit to us a PSIP budget, that we'll be able to make representation on your behalf. Now, you all already made representation, but we are willing to hear you again with further representation, because I believe you would have come before us with recurrent expenditure. We are willing to hear you on a PSIP proposal as soon as possible.
Well, that's hopeful coming from you as well. I think they've gotten the message, and I think we can move on from there and know that things will happen like last week. Yes? Mr. Rowe is certainly going to be moving on that, and his team. Now, you did say, though, that you have been making representations for amendment of the legislation in terms of the number of areas that are covered.
Yeah. So
let's hear you on that.
Well, in terms of recommendations being made, there was an ad hoc committee set up by the Attorney General's office under the auspices of former Attorney General Mr. Salwari, and the former chairperson of the Equality Commission, Dr. Let me see, where is it? So, I'm sorry, Dr. Sibaran, was a member of this ad hoc committee, and I guess it probably went cold, right? And I had several meetings in recent times with the President Attorney General in terms of bringing this, giving some activity to the ad hoc committee so as to advance all the work that has been done before with them, right? And there's a document I don't know if we share with you all, or we can share with you subsequent to this hearing, where we will have put forward certain recommendations for amendment, and this ad hoc committee will have been engaged with other units of government in trying to identify what necessary legislation ought to be amended so that it will be all probably done in an omnibus legislation or in dealing with giving some sort of serious consideration in terms of implementing and taking up the recommendations as proffered by us to change to update the Corporate Opportunity Act. But more importantly, and this brings it to a very sensitive part, what we have been saying, notwithstanding the amendments, I think the equal opportunity as it exists under this Equal Opportunity Act needs to be repurposed. And what the whole emphasis of this and the former and the most recent board is to get Trinidad, get the Equal Opportunity Commission to be transformed into the Equal Opportunity into the National Institute of Human Rights of Trinidad and Tobago, which would amplify the mandate and cover a lot much more of the areas of where we have identified of disability, not disability, but discrimination that have not been addressed specifically by the Equal Opportunity Act, because it's limited, as we said before. There are just 4 categories on which you can go under, and you must fall within the 7 status wrong in order to legitimize complaints of discrimination. And as I am saying that as well, so there's this document in existence. There's a document called the report initial on the Convention of Human Rights and Disabilities and so on. There is a report for the recommendation to amend the Equal Opportunity Act generated by that is a part of the information of the Ministry of Legal Affairs, and probably the people that said Ms. Cheney might be able to lend some clarification to where it is at this point in time. But what I want to say where that is concerned is that probably in giving this whole holistic revamping of the Equal Opportunity Act, and I've done a lot of reading since being there, is that I think that the Equal Opportunity Act was a very necessary piece of legislation that came into existence. The forefathers to this also were very wise in making the essential part of the Equal Opportunity Act to be a dispute resolution type of activity as opposed to litigious. But most importantly, what I found it is running short of is that equality, as I become more focused in the operations of the Equal Opportunity Commission, equality does not necessarily lend itself to what I think people of Trinidad and Tobago need at this point in time. What we need is equity, because equality in itself seems to be the end game. But how do you get there? You can only get to equality if you have equity, and that is what we need to be focused on. So probably even if the act is, if we are not going to achieve within the space of time that I am here as chairman of this board, and the amendments that we made probably should be made to have the equal opportunity and equity commission, because without equity, you can never get equality. So equality is the end game. So because what you have in it, and I keep saying that the more and more I look and more become more involved in stakeholders, and so you see that there's not so much a problem with equality in Trinidad and Tobago. For instance, primary school education or getting to the university, there's no discrimination in getting in there. Anybody can apply to get into university West Indies or get into a secondary school. It's mandated everybody is supposed to go to secondary school or primary school at a certain age. But how many people really can, when they get, if you do get into the school, how many of them can achieve to get proper education or be able to do the exams to get them into to advancing on an equal basis. Many can't. People coming from a dysfunctional family, people who are disabled, and no provisions are being made to bring them up to scratch so they can equally have an opportunity on an equal basis to be able to on an equitable basis to be able to achieve the equality of death and good entrance into the exam. That is not in existence. And Madam Chair, with the greatest deference, I know you are a champion for children's rights, women's rights, and so forth, which are disadvantaged sector of our society. As a member of the differently abled member of society, discrimination in Trinidad against the disabled is significant, woefully embarrassing, and on a daily basis, it is a sad state of affairs to be in. And as I look around the members who are taking part in this hearing this morning, if you look among yourself and ask anybody, how many of us here have somebody who is disadvantaged, some disability working for them or in their, I'm sure it will come up with zero, if one. When I was a chairman, when I was in your position, when I was a senator, as an independent senator, a few years ago, I invited almost on every occasion of my budget contribution to ask the members, the 41 members of Parliament, one day come to work with a wheelchair and see what it is like for somebody who is differently able to get around.
Nobody took up your offer.
One person did that, and that was the Speaker of the House, Ms. Bridget and George. Came to work one day, and after you finish with it, you give it, make a donation to a charity. One person. No person that is differently able, be it hearing, sight, or whatever it is, wants to be disabled, wants to be a liability on the state, wants to be a liability to their family. And it takes a lot to get to live a normal life as a Trinidadian to be as a disabled person. It takes a lot for me to live the way I live. And if you look around, how many members in 41 members of Parliament, how many of them are differently able? I haven't seen a disabled person here. How many people in government offices are differently able in some form? People don't want to rely on the charity, on a handout of $2,000 a month. That can't do nothing. That can't even buy basic things for me. Right? So when we're talking about equal opportunity, yes, we have an Equal Opportunity Commission, right? But is it really that the problem? What is the problem in Trinidad and Tobago? Is equity, putting people in a position where they can have a fair chance to be equally treated, to participate in what is equally available to all. That is
we have a great advocate in you, and I thank you for your passion. But unless people are made aware and you continue to make people aware of how you treat people differently, that or you don't cater for their differences, there will be no change. I can tell you, because until the people from the blind welfare came to the legal aid clinic at the law school and engaged with us, we were able to draft the law to change so that they could vote by a companion. So all the years that never happened. And having done that, after I put it in the lawyer, nothing was done. It was published. But when the newspaper, weekly newspaper, published the paper that I had written, that is when Mr. Lawrence Mirage took up the law and was able to bring it to the Parliament. He didn't even change a comma so that people could vote by a companion. So unless you have someone advocating and working in the field, sometimes it's just under the radar. And I had a special interest because my father was differently able in terms of his sight. And I can tell you, after I was instrumental, when time come for voting in the election, he didn't take me into the voting booth with him, He said, no, I ain't taking you. You might put my vote in an area where I don't want. You might vote for NJAC. So he took my other sister. So, that is how sometimes things operate. We have to continue to advocate. But I want to also say that we must look and see what is happening sometimes regionally and internationally to see where we ought to go. And when we look at the areas in our legislation and we compare it with Barbados, we compare it with Guyana and St. Lucia, we see that our areas are very limited. Barbados has 19 areas. We have nothing in our laws about political opinion, trade union affiliation. We don't even speak about color. Some of us do not remember 1970. When you look at Barbados, you see they have all of those things: creed, sex, sexual orientation, social status, marital status, domestic partnership status, pregnancy, maternity, family responsibility, medical condition, disability, age, physical feature, any characteristic which appertains generally or is generally imputed to a person on the basis of any ground referred to in paragraph A to R, all right? So all of those things. When I applied for the job at the law school, they asked me if I intend to have another baby because my baby was 3 months old. Totally inappropriate, all right? So they asked a question, I gave them an equally stupid answer, but I got the job. So that if you see also what is happening in Guyana, you see, again, they have things like political opinion, not only disability, indigenous population, national extraction. Our indigenous people are also crying out. You have social origin, pregnancy, marital status or age, except for the purpose of retirement, restriction on work. You know, so it is much wider when we look at Guyana, when we look at Barbados, when we look at St. Lucia. So when you're making your representations, again, to the Attorney General's Department, I would suggest that we include other areas as well, all right? Because we can't hide our problems. We do have problems in these areas, so we need to know how we are going to address them, but we need, first of all, to highlight them. I would like to hear from Mr. Hislop. I'm sure he has a burning question to ask of you.
Thank you, Madam Chair. I was taking in the entire conversation this morning, very riveting with the legal minds at work. But I am really concerned about the public awareness, because the Equal Opportunity Commission is one of those commissions that, and I say this very tongue-in-cheek, but it's one of those commissions that does not exist until you need it. And there are limitations to treat with. And so my question is, outside of what the law allows the commission to deal with, what are some other areas that the commission has been receiving complaints that they are unable to treat with?
Madam Chair, through you, if I could quickly, what jumps at me is age discrimination is one, right? Sexual orientation is another. There's also the cohabitants. You have the Cohabitation Act, but yet it is not provided for as a standard as under the categories of discrimination, right? Disability needs to have is limited in its definition. Disability needs to take on a much more expansive definition of what disability is. So those are some key areas. And if well, as I said earlier on, what will really complement and make this a wholesome and useful institution in terms of redressing inequalities in society is to amplify or repurpose the Equal Opportunity Commission from being the commission that's dealing with 4 categories or 7, because we have 4 categories standalone for discrimination, and have this designated as the Human Rights Institute of Trinidad and Tobago, where all the number of human rights treaties and conventions that we have been signing internationally, United Nations and so, can be purposely implemented, because a lot of them we have signed and ratified, but yet still is not part of our domestic law. So we have policies, we have been negotiating policy. There's a lot of talk, and you know, one of the things I do not miss from being in that parliament is the amount of talk and the lack of activity to follow through the talk that you talk and you discuss. I thought I would have been given the privilege to be where I am, and the only reason why I'm taking it, I have taken it because of my condition. Why on my legs I may not have been as sensitive as some of you all may be in terms of this, unless you have encountered somebody who has been differently able. It is not easy. So you can see the obvious needs that are that can be addressed in the institution with much more teeth. And another thing that is shortcoming, the institution of the Economic Commission, yes, it was envisaged to sort of ameliorate, promote equality of treatment, lack of discrimination, and so forth, but it does not have teeth. Like, for instance, the Police Complaints Authority can investigate, as well as police may have something committed a crime, what it is, and it involves police officers. They can investigate to make sure that things were adhered to by the police officers or whatever it is, really and truly, right? The Equal Opportunity Commission, in trying as one of the main institutions dealing with bringing about the ending of discrimination and inequality of treatment, has no means of investigating outside until it is. In other words, we are inactive until operated by a person coming to make a complaint. We cannot take it for our own initiative to go and investigate something, because over the last year or so, I mean, we have been listening before media releases all the time. We monitor these things, and you hear utterances by people who should know better to utter, unfortunately, either racial undertones or some sort of discriminatory unpleasantries, and we can do nothing about it if somebody doesn't come and complain. So that's a limitation of the Equal Opportunity Commission as it is right now, and that needs to be addressed if you want it to be more forceful, and if you really want to engage in a way to bring some resolve and to make things, put people on the spot, that you cannot just give liberty to speak in this kind of way in today's world, where we are trying to get a more unified type of society. We want to get a society where people don't look at color, race, creed, sex, or anything, and you just look at another human being. That is the only way we'll achieve true lack of discrimination and unity. And you look at somebody else and you see a human being, right? You don't see black, you don't see white, you don't see Indian, you don't see Chinese, you don't see Christian and Muslim. We are all human beings. That is what I think I would like to see achieved here, right? When I had a stint, and some of you may know my background, I've been in South Africa during the time with President Mandela, right? And he gave up his life, his family, and many others who a lot of people may not have known, who have lost their life in trying to bring equality in among a country as significant as South Africa for so long. And many of us in the diaspora, many of us in the outside world help to litigate and bring about that change, that they could live in a society where people could be judged and given opportunities on their merit and not how they look, which they had no choice in the very beginning in coming into the world. And this is what I think at Equal Opportunity Commission, I would like to see. If I'm there for a couple more months or a year or whatever it is, what I would like to see is that makes some significant difference, that people start changing the way they speak publicly, those who are in positions of influence, and speak in a more holistic way, speak in a more human, sensitive way, that we engage each other as we like to be treated by another person. And that is easy. Once you look at somebody and you treat them like you would like to be treated, there's no even need for law. There's no need for morals. There's no need for ethics. You deal with a human being with feelings like you are. And with all my travels, where I've worked all over in several places, parts of this globe, one thing in common I have found is that people have more commonalities than they have differences. But for some unfortunate reason, we tend to highlight the negatives and the differences as opposed to the commonalities. And if the Equal Opportunity can be championed in doing that, I think Trinidad and Tobago will deliver on the potential that it has as a society that is diverse in all aspects of humanity. Because I think we are a rich and privileged society. To be born in a society where you have all these different races and all these different cultures, man, it's just blow mind. If we could just come together and look and deal with each other as human beings. The balance that's going on here, police will lose their work, lawyers will lose their work, right? You have to look for something else, because people will be more humanistic and it's easy, more pleasant, more love. It may sound simplistic, but that is what life is about. We focus on all the accessories that is not life, to categorize people, to judge people. But if you look at people as human beings and give them an opportunity to be the best that they can be, I think we will be in a better society.
Thank you, Chairman. Madam Chair, just one other thing, and I'll be fine. Mr. Rhodes spoke about the role of the commission with regards to what he's very passionate about, and I want to ask if the commission is considering a public campaign with regards to, especially when he spoke about the difference between equity and equality, and about how we treat each other. Is the commission considering in the near future a public campaign that will bring these things to the fore about how we treat each other as human beings?
Madam Chair, if I may answer Member Hislop, thank you very much. And we have that in our focus, but I think having coming from you in the way in which it is now being presented, I think it will be with some level of urgency to get such a show in trade as soon as possible, because I think it's necessary. I think it's necessary because if you walk around Trinidad, I mean, I think there are another thing we need, Madam Chair, as we have the opportunity to be speaking to the Joint Select Committee, is that a census needs to be done to update the understanding of perception of discrimination and so forth, what the mandate of the equal opportunity. And that could only be had through a national census. We were trying to get it, we were put on hold because a national census is supposed to take place. What we are dealing with is data from 2011, which is really outdoing its utility and its accuracy. So we really need to have that done urgently, where these things come in, because the last census did with people with disability was 52,000 persons in Trinidad. I'm sure that is much more than that, because I wasn't a member of that at that point in time, right? So I think that because it will help to focus the government and policymakers to know how they need to treat what urgency and how significant that population is, because without capturing them in your planning and so policies, you are losing out of a serious opportunity of labor contribution, people that can contribute in a meaningful way to society. Give me one of the reasons, I mean, not to talk to censor myself, but I'm just speaking, the reason I took to go into Parliament as an independent senator, being differently able, as the president was able to persuade me at that time, is because I represent somebody that has some skill, some ability. So people don't look at your disability and they look at your ability. It's the same thing in the Equal Opportunity Commission. Why not in this position? I would not have gone in and taken it what it is, right? Because I do make my contribution quietly. I work out my society and help who I can on a one-to-one basis, and that can amplify, because that domino effect, you help one person and you make a difference in your life, and we can go on. But I think visibly being in a position of visibility and seeing that, wait now, but this man is disabled or this woman is disabled. Like there's a person who is now in the Equal to Tribunal, and she writes with her legs, with her feet, but she's a lawyer, right? So that is something to be highlighted and promoted significantly. And we are not the only two. There are many other persons who are outside who do not want to live off a disability grant, want to be effective and can make significant contributions in society in moving us. And that's a productive persons or sector that is being marginalized or being ignored or underutilized or under access. We need to see more people with differently able all over the public service, all over the private enterprise, doing things and so on. Then people will be treated differently. What I have made I have made a point that I am not patronizing any facility, any business in Trinidad and Tobago that do not have a proper ramp or any access to go there. You have to follow up in advance. Do you have a ramp? Can I get there? No, I will lift you up when you come. What nonsense is that? When I go abroad, I can't even go to Tobago. I haven't gone to Tobago. The last time I went to Tobago was 2011, when I was chairman of where the portfolio of the THA fell under my portfolio, just as the Joint Select Committee here, right? And they also lift me up to take me to the plane on my wheelchair. There was no song that you can roll on and go on as you win international. There's no beaches in Tobago. I inquire from all my friends that live in Tobago. Those who live there and those who those who visit there frequently. Is there a beach that I can go to? You know what I do when I want to go to the beach? I jump on a plane and go to Curacao. Or I go Cayman Islands. Right? When I'm abroad, I go abroad for medical purposes in the United States, in Florida, I feel as though I'm not paralyzed. I can go anywhere at any time without any special allowances made because they cater and they include persons of disability into their society so they could be meaningful and they are productive. That can't happen here. People that have been disabled, they stay in a house, they became invisible. They're not seen. The technology has advanced such a way that I am privileged to be in this situation. I can sit in my home and carry on this hearing without any inconvenience. As an attorney, it's not for me to go to court. I have to call a friend's phone if I can get a parking, if I can get the city elevators working. That is not the way to keep it. If you want to deal with really discrimination and make it equality a reality, we have to start with equity. What do you need that is reasonable to bring these people into play that they could be part of society? And it starts from it's very, very self. You all who are investigating us, who are calling upon us to see how you can assist us, look in the precincts of Parliament. How many people inside there disabled? How many people working in the offices here have some disability? Barack Obama, when he came as president of the United States, he made sure there was a percentage of federal employees that must be differently able. Why can't we mimic that?
Mr. Roach, if you don't mind, I'm sure you, Chair, I want to commend the passion of Mr. Roach on this particular matter. What he's referring to and the type of society he's referring to and where we should be as a society, I think all of us here on this committee, as well as in the Office of the Attorney General and the Equal Opportunities Commission, I think we all share that view and we all share that passion. And, you know, while you were speaking, Mr. Roach, you know, it just reminded me of, you know, this concept of rebuilding a Caribbean civilization or rebuilding a civilization of love in Trinidad and Tobago. And in rebuilding that civilization, we have to look at all the institutions of society that must play that role in rebuilding that civilization. It starts with the family and how we treat each other. It starts with our communities and how we refer to each other, especially persons with disabilities or differently abled persons, our churches, our schools. All of these institutions must play a role. A couple of years ago, we did not have an institution called the Equal Opportunities Commission. That came about as a result of our evolution as a society. And therefore, today we can sit and have a discussion on equal opportunities and what we can do to expand the role and the influence of the Equal Opportunities Commission as we craft and we continue to build this civilization that we all desire. So yes, it is not perfect. We wish that we could have been far more advanced. But I also recall a couple of years ago, there was no disabled or differently abled access to the Hall of Justice. There wasn't the same for the Parliament and so many other public institutions. Now I'm seeing a greater effort on the part of the state and some other private entities to cater for persons who are differently able. I recall many years ago, you could have gone into a public institution or into a restaurant and you would not see a park for persons with disability. You're now seeing a greater effort. Of course, there's a lot of room for improvement, and we wish that we can mass the accelerator to expand it and to really get to that destination where we all desire. But just to support what you are saying, it requires all hands to be on deck. And it requires all of us, all institutions, public officials, the way we speak to each other. I'm telling you, even in the politics, you hear persons who are political figures inside the Parliament of Trinidad and Tobago speaking about each other in the most degrading form. And we are not persons with disabilities. But the way in which we speak to each other and talk about each other on our social media platform, you can't believe that these are people who are sitting in the Parliament of Trinidad and Tobago. And that is where it starts. And if it is happening at this level, then one can only imagine how sad and how difficult it is for our citizens who are differently able. But in order to move forward and to advance the interests of Trinidad and Tobago, we have to really look at deconstructing and reconstructing that civilization that we so desire.
Must remember, thank you, Mr. Gonzalez. But remember that differently able is not always something physical, eh?
Of course.
So that people may be differently able psychologically and other ways. So don't think that you know, you ought to look and see somebody physically challenged. It is not always that way. All right. So that maybe you need to have psychometric testing. Not only they said they do it for the judges, that we could do it for members of parliament as well.
Parliamentarians, I'm sure, because many of them would not be, or many of us may not be sitting where we are sitting right now.
All right. Now I want to move on to something else though. There has been for some time a debate as to whether sexual harassment came into the legislation. And that has now been clarified by the judgment of the Court of Appeal. So tell me, members of the commission, have you thought about it? Are you planning to do any public awareness campaign to highlight the consequential change in your mandate, that people will be aware? I mean, you know, we have a national workplace policy on sexual harassment, but really and truly, sexual harassment is still continuing. It's alive and well at various levels. Do you plan to do a campaign to explain to people that here is an avenue that you can deal with your complaint, so that, again, it may not be a matter that will need to go to the industrial court or to the high court, but this is another avenue for you. Because I really have a concern that you, the commission and the tribunal may be underutilized, and we really can't, in this state of the economy, we can't afford to have resources that are not fully utilized. So we will champion your cause to get more human and financial resources. But in terms of what you can do to make a better society where people are happier and safer, you know, all that comes into it, what do you plan to do? What have you started to do? What can you do in this area?
Chair, thank you very much for that. And that is very important consideration. That is an activity we have been discussing in the commission following the decision by the Court of Appeal recently. I would just say a bit, and then I'm going to ask Haran to give some further clarification on what the implication is for the commission. And also, I'm going to ask Ms. Darabai after to lay out to the public, to yourself and the public, what we intend to do where those things are concerned. It's all part of our strategic plan and our initiative in educating and bringing to the public a sensitization of what are the issues that are alive, what is covered by the present act, and what we are doing to help to include others that are not being protected under the act. So, Haran, could you just amplify the position of the commission where sexual harassment has now been, instead of just waiting for the legislative change, we can now act upon it without the act being amended at the commission?
Yes. Yes. Thank you. Thank you, Madam Chair. By and large, we had always advocated that sexual harassment was a form of sex-based discrimination based on international judgments from other countries, that have equal opportunity legislation. Because the thinking behind it was that if you suffer a detriment because of your sex, then you have suffered sex-based discrimination. And just to stick a pin, Madam Chairman, while you mentioned Barbados might have discrimination based on maternity and pregnancy, under the same common law that interpreted sexual harassment as a form of sex-based discrimination, the judgments in other countries have also interpreted discriminating against a woman who is pregnant or in in a period of maternity as a form of sex-based discrimination. Because the thinking is that only a woman, there's all this talk in the United States about what is a man and what is a woman, but traditionally only a woman can become pregnant. So therefore, a man cannot suffer discrimination on account of pregnancy. Never mind what we see in the United States media, but a man cannot suffer discrimination on account of pregnancy. So that if a woman suffers discrimination because she's pregnant, that is sex-based discrimination. So that we have said that we can entertain complaints on that basis. Following, we had actually published and prepared guidelines, going back to sexual harassment. We had published guidelines on sexual harassment, which was available for download, free download. And following the publication of our guidelines, we had done a fairly intensive publicity campaign. And we had been invited, in fact, by many, I had spoken earlier about the fact that we were invited by many employers to come into their organization. We have been invited by many employers to come in and do training on sexual harassment. We have actually been approached by many organizations to provide comments and feedback and review about their sexual harassment policies, because one of the things we advocated for in our guidelines is how to write a policy. And we have said that if an organization wants us to review and to vet their policy, they can do that. So we had done that. Following the judgment, however, of the Equal Opportunity Tribunal, which had ruled that sexual harassment was not a form of sex-based discrimination, that work necessarily went on hold pending clarification from the Court of Appeal, which, as Madam Chair pointed out, came which we were very grateful for last year in March. We did engage in a certain amount of publicity coming out of the judgment to inform persons that we are now available, capable of receiving these complaints. And we have been receiving these complaints. What we found is that it may not be necessary for every member of society to know that sexual harassment is a form of sex-based discrimination. I believe as Member Hislop hit the nail on the head. When you need our services, you can find us. So that we found that we have been receiving a number of complaints from persons. There's one complaint we're dealing with right now, where a woman said she was terminated from her employment on the grounds of her pregnancy. So obviously the word got out there. Maybe she may not have known at the time she was terminated, but at the very least, if she consulted an attorney or a trade union or an IR consultant, they were able to say, hey, you can lodge a complaint with the Equal Opportunity Commission. So that has been by and large what we've been doing. It's not so much that we need to let every member of society know this, but at the very least, the people who are in a position to channel the complaints to us must be aware of that. And with that, I'd like to defer to Ms. Dollabile to tell you more about some of the work that we've been doing.
Thank you, Haran, and through you, Madam Chair. We did embark on a awareness campaign when that judgment was handed down. But of course, this happened in the context of severe financial constraints. And so we were able to utilize the mechanisms that were free to us, such as the mass media. We put out a column series, 3 columns actually in the newspaper. We published articles in our external newsletter to our extensive stakeholder listing. We made appearances on the media, such as the TPT Now program. Also in that Sex and Prejudice program that we had, we dedicated one of the episodes to sexual harassment as a form of sex-based discrimination. And we also put out content to social media. Also importantly, as Haran mentioned, is that we pushed the information to organizations. And so in the inclusivity training that we conduct the various workplaces, we have seen an increase in the requests for sexual harassment training. And of course, as Haran said, that's not reflected in the complaints that we receive at the Commission. But I do agree, Madam Chair, with you, and provided that we are able to get some financial resources, that we'll be able to embark on another campaign that we can reach more pockets of our society, whether it's young people on social media and so on. So we have done some work, but I agree that we can embark to do some more.
Have you engaged with the police at all? Because there was some story about sexual harassment in the police service. I mean, this is something that is ongoing. I did do a session with them years ago, about 2004. So, there were several complaints, and I advised them about a sexual harassment policy way back then. And recently, I think maybe it was last year, there was something in newspaper about that. I mean, we don't want any of our policewomen being demoralized.
Madam Chair, if I may, right, that is very, very critical, because I think in my first year as in this position as chair, I did reach out to the police commissioner then to embark upon the EOC, some sort of joint program where the EOC could have come into or work along with the police, within the police and outside the police in their communities, outreach. And those discussions were taking place, but I guess with the heightened amount of criminal activities and the police coming under a lot of focus, and so I think somewhere that was not able to come to any fruition, and there were changes in the hierarchy of the police service, where the defense force is concerned. I did have some conversation, not I think with the CDS, but with some other members of the hierarchy within the military. But I think it's something now that you are brought forth again, that we will engage formally with all the services in Trinidad and Tobago, because I mean they touch so many different lives on a regular basis. So I think it'll be a very good place to penetrate, to get our message out and to sensitize and educate. So we thank you for that suggestion.
Sorry, Madam Chair, if I may, through you, we have in the past engaged with the Police Service Training Academy, was commonly called the St. James Barracks. We had in the past worked with them on developing training programs. One training program in particular was their response to domestic violence, but this would be training program for new recruits coming into the police service. It would not be applicable to the 4,000 or 5,000 or so officers that are in the service. We've also we regularly engage with the Defense Force to provide training to their members on the Equal Opportunity Commission and the Act and what have you. But as one would appreciate, there are different areas of the Defense Force, so that we might have worked on some areas, but not on others.
Thank you.
Madam Chair, if I may, just if you can indulge me, I have been in meetings with the Permanent Secretary of the Ministry, the Attorney General of Legal Affairs, and I got with some way of message was sent to me that a number of the financial woes that we were lamenting about have been taken care of in their budgeting. So I think the next time if we were to come before you, I think that we will be properly or better resourced in dealing with some of the programs that we identify. Apparently, whatever has been put forward to the ministry has been accepted or and is being sorted out. So I just want to put that on record, that we seem to be getting the resources that we require. I think that would be good news for Shelley.
It's a pity you all missed the media review, You've gotten some money there.
For sure.
Now, in your submission, you say that the Commission has set a strategic objective of becoming the National Human Rights Institution for Trinidad and Tobago. I just want to know, though, what steps have you taken to meet requirements to become this organization? And what are the major benefits of becoming such an institution?
Well, first of all, Madam Chair, thanks again for that inquiry. It is a process, and the process starts with we make a recommendation. The Commission have been made recommendations to the Ministry of the Attorney General and Legal Affairs. That is a program, an initiative that has been taken by the former board, and we have ratified it. We have continued, and we are now trying to push it forward with a certain amount of urgency. So it is a comprehensive document, a comprehensive proposal that was put forward to the ministry, which is under active consideration, because my most recent meeting consultation with the Attorney General, he asked for some time to go through it with his team in terms of seeing what is the next step need to be done, because we gave a very comprehensive profile identifying other such institutions globally and the different incarnations that they have, because it is not a one shoe fit all. And in terms of how to deal with the type of mandate that would be required to make us that, because it may not be necessary in all instances to have all the rights under this Human Rights Institute, because you have, as you know, you have the Children's Authority and different authorities that be doing something where they are protected. But this Human Rights Institution will be able to have a more broader perspective, much larger reach to dealing with all forms of human rights abuses. So the process is there. So where it is right now is in the domain of the Ministry of the Attorney General for consideration. And I think that it may be. I think what was suggested to me is that the Attorney General, with his department, will review it with his experts within the ministry, and then I think they may make some sort of a representation. I don't know if they're going to go out to the public for their views, and then probably the necessary approach to cabinet may be made, because it will require a change of policy, amplification of. Sorry.
Oh, sorry. I'm saying as well as legislation.
To achieve that. So because in having that assignment achieved, it will certainly require a significant level of total independence, really independent, because we are quasi-independent. We are independent in terms of our functions, in terms of investments, but in terms of being to hire our own staff, we are not, even though it is provided for in Section 29 of the Equal Opportunity Act. The arrangement that took place between the initial chairperson when the EOC came operational in 2008 and the then Attorney General, Senior Counsel, Anna Ram-Logan, they made an arrangement by a policy where the Ministry of the Legal Office of the Attorney General and Ministry of Legal Affairs will provide staffing, because to have staffing being done by the Equal Opportunity Commission, you will have to have certainly, as required by the audit and financial regulations and law, an accounting officer, and there's no such accounting officer in our commission. There's accounting, and you will know we are operating almost like the Holy Director of Public Prosecution operates a department within there. So the accounting officer, which is a necessary requirement for dealing with public funds, must be a provision, because there's a lot of responsibility with a lot of consequences for the public officer if there's any transgressions, personally and otherwise. I mean, in terms of finance and in terms of imprisonment. So all of that in trying to transform it to the National Institute of Human Rights Commission will require serious consultation and advice, because we could either be a state enterprise, it could be a corporation like Tiantec, So that is, I think, is right now is in the ministry. So I don't know if anybody from the ministry, probably Deputy PS, wants to say anything, or she has sight of it. But my most recent meetings with the current Attorney General, we discussed this very much as a priority issue for the Commission. And
Chair, Chair, if I may, I'm not briefed on the matter, but I will certainly liaise with the Honourable Attorney General and get an update for you.
Thank you very much. We had an anonymous submission. I don't know if you can respond to this, Mr. Chair.
Yes.
Yes. The commission's operations ought to be streamlined and bordered to become more efficient and to eliminate inordinate delay and to prevent scrutinizing complaints judicially, which is the preserve of the Equal Opportunities Tribunal. What are the commission's operations which are prone to delay, you would say? Is that a valid comment of this anonymous person?
If I may, Chair, if I may respond to that, I don't necessarily think that there's any undue delay in the commission's operation, other than what was highlighted by Mr. Haran Singh earlier on, in that it's a process. And even though it's not litigious, there is a process here. You receive a complaint, and the process in itself could at times lead to unduly delays, right? Because people will ask for time, people will be required to submit this and different things like that. And that in itself takes up time, right? Because it can go from for a few weeks or a few months. It depends upon the parties involved, right? Remember, this is a voluntary type of situation, and only in a direct, deliberate transgression of a requirement that the EOC may call upon one of the parties in the investigating complaint to produce a document or to be visible, and they don't, then they may have to take legal action. And so, but outside of that, I do not think there is an undue delay in dealing with matters at the commission in terms of complaints. And I don't know if Haran wants to add anything to what I've just said here.
Yes, Madam Chair, our function is simply to not just refer matters to the tribunal. And I think that's something we had discussed earlier. So although we might get 100 complaints, let's just say 120 complaints for the year, the statistics show we might only refer 2 or 3 matters for the year to the tribunal. That a lot of the matters that fall by the wayside are matters, for example, that don't fall within our jurisdiction. And it is our job to review the matters to see whether or not it falls within our jurisdiction. And to that extent, while we're not usurping the tribunal's judicial function, but we do have to exercise, for want of a better word, I'm just searching for some sort of a quasi-judicial process to see, does this matter fall within our jurisdiction or not? Then matters may be resolved through the investigative process. For example, just by investigating the matter, a complainant might now feel more satisfied. They might feel, well, I have a better understanding of what happened. And our investigations tend to be very thorough, because in an investigation, we don't simply see it as, tell us what you would like to tell us. We don't tell a respondent, these are the allegations, just say what you want to say. Instead, we provide them with a list of questions. We want you to answer these questions. We want you to provide us with these documents. We want you to provide us with these statements, these reports, these records. So it is a very voluminous process. And that is what we see ourselves as doing. We're performing a thorough investigation, and that in and of itself is not usurping the tribunal's function, but it is simply doing due diligence in our functions, ma'am.
So you would say that you have been updating the complainants as to progress of their matters, and is there any way or opportunity for engaging with the tribunal even outside of this formal process at all? Any virtue in that, any advantage in that, any necessity for that?
Well, ma'am, under the schemata of the Act, matters only go to the tribunal, and I believe you quite correctly quoted sections 39 and 40, only after we've investigated, we've done our report, and we send it there. So I'm not sure really if there's anything to liaise with the tribunal about. In matters, for example, that have gone before them, if they wanted legal arguments or submissions from us, or in the past, if they wanted documents or material from us, they would request it from us. They do have the power of subpoena as a high court. They have a number of powers similar to a high court, including the power to subpoena records and documents. So I'm not sure really if there's, at least from my perspective, and I will defer to the chairman, but I'm not sure if there's any need for any further engagement with the tribunal.
Yeah. Madam Chair, as I said earlier on, one of the gray areas in our mandate and our powers is that when you talk about we are to refer matters if it's not resolved by the conciliator process, and then to become active as though we are litigating on behalf of the complainant. to me it causes a bit of false expectation and a lack of a clarity, judicial legislative or judicial clarity of what exactly referring a matter means. Do we actively get involved? We say to refer, or do we actually pursue the matter thereafter? So people have that. So that creates a sort of a catch-22 situation, because we are actively involved in referring the matter, but then once we refer, the interpretation that we have is that is the end of it for our participation, or that's invited further by the commission. Because one of the things in conciliation, once you conciliate it, people are free to speak openly and think that nothing done or said in conciliation can form part of the record in the tribunal, because otherwise it will stymie the whole integrity of the conciliation process. So these are things that I think even in our campaign that we have to sensitize the public in a more clearer way, give them more concise, cogent explanation of the process when you lodge a complaint and what it is. Because apart from being aware, when you come, I don't have a false expectation if things break down. And what the director of legal services is saying at the commission is that many of these matters that come before us sometimes are resolved even without great conciliation, because when you start to investigate and people come face to face with each other, they see things in a different perspective, a misunderstanding. And many instances, even the outside, in the contentious world of litigation, my experience is that sometimes when you deal with people and bring people together, sometimes a lot of things that people will have misconceived or be agitated about, or to think that they need to have it taken to the court. When they come in a setting that is less threatening and more open and understanding, matters are resolved quickly, without the need of the intervention of a judge, even though it may reach, So the EOC aims is to do that in a very successful way, where there is legitimate complaints, the large number of complaints that is in fact fall within the remit of the institution. And as he said, just like you do in judicial review, not because you file a judicial claim matter in the High Court, it means that you're going to get leave for the matter to be heard. There must be some sifting out, so you must fall to see whether or not this complaint. So, but come, as he said, there's a case of bias. Bias is not catered for within the remit of the Equal Opportunity Commission. So obviously that would not be referred, dealt with, or even referred to the tribunal. So I think we have some work cut out for us in terms of sensitizing where those things are concerned. What is to be expected, what we can do, and what we hope that can be changed to make our services and to meet the needs of the society as they transform and become more sensitive to their rights. Because I think people are becoming, in this time, people are much more sensitive to their rights, to their human rights, and do not want to be advantaged in any way. And an institution like the Equal Opportunity Commission, which fills a gap that the Constitution did not cater for, because, as you know, constitutional matters are between the state and the citizen, whereas the Equal Opportunity Commission covers both private and public sector, which gives it a lot of purposefulness in the society. So I think our work is cut out in terms of making the public understand what is our remit and what is to be expected and not expected from what we can do and what cannot do.
Thank you, Mr. Roach. Unless there is something else, we would move on to closing statements. Any other member had any other burning question? Yes?
No, Madam Chair, from my end, I think I'm good.
And Mr. Scotland is all right.
I am fine, Madam Chair.
Okay.
Just to say that, I would not, I'll leave that for you, Madam Chair.
Sorry?
No. I was about to commend Mr. Roach and his team, as well as the team at
we've had a
for you.
very robust session. It's never the same as when you live the story.
Absolutely.
Yes, you lived the story. So I really would invite brief closing comments from the chief officials, unless Mr. Rhodes will think that we've exhausted him. He's made comments. Do you have anything more to say?
All I will say in closing, Madam Chair, and I do want to thank your members, yourself and your members, for this quite interesting and hopefully edifying session that the public becomes more aware and advance the purpose of the EOC. What I will say is that, as I said earlier on, that equality really and truly is Equal Opportunity Commission. Equality is the end game. Equity is the vehicle by which you get to the end game. And as our well-known, well-respected former human rights activist who lived the life and experienced the ugly side where you are not treated either as equal or subhuman, former President Mandela, he said, everything is impossible until done. I hope this will be done. I hope we will achieve the equal opportunity we will achieve, if not through my tenure, somebody else's, that we have achieved a society that reflects who we are. We are mixed and we are one people. We are Trinidadians and Togolese. That is what I want to see. When I'm abroad, I feel proud to talk about my society. I used to boast about it when I was in South Africa to President Mandela until he came here. I said, you talk about the Rainbow Nation, come to Trinidad today, you'll see Rainbow Nation. We don't live side by side. We integrate in food, culture, religion, everything, right? And when he did come, and he came back, he did say to me, what you said was true. I thank you.
Thank you, Mr. Roach. Office of the Attorney General, Ministry of Legal Affairs. Closing comments, please.
Sure, I'll be brief because I know everybody wants to go for lunch. I would just like to say that Mr. Roach's impassioned advocacy on the part of those who cannot advocate for themselves, I'm sure it has moved everyone on this committee. And I can speak for AGLA. We stand ready to assist in any way in which we are called upon.
Thank you very much. So there is some work to be done. Mr. Roach, you're aware to move this process forward. You've taken note, and we also have taken note of the constraints under which you're operating, the need for amendment and so on of the legislation. And the advocacy continues, to bring people up to the level of awareness. And also remember always, Mr. Roach, to use the politically correct language for the persons, non-disabled person with disabilities. We have to change that in the whole context of how we do things. So our whole language must change. So we look forward to the changes for which you advocate. The Attorney General's office seems to be very anxious to assist you in amendments to the legislation. You have to let them know exactly what is required and the resources that you require to carry out your work. Very important work. So I wish to thank you for coming here and sitting with us and talking with us. I wish to thank members of the committee who have come and sat with us today. Thank you very much for being here and for your contributions. And I end with a quote by Adam Clayton Powell: unless man is committed to the belief that all of mankind are his brothers, then he labors in vain and hypocritically in the vineyards of equality. Enjoy your lunch. Thank you and see you next time.
Simply.
Thank you very much, Chair. Thank you, everyone. Bye.
Thank you, Madam Chair.
Thank you, everyone.
Thank you.
My assistants here, the secretariat, as always, can't do without them. And we